presenting before you the legal updates for today live from the Honorable Supreme Court of India. The President has approved the conferment of the Padma Vibhushan to former Chief Justice of India Justice J.S. Kheir. Justice Kheir served as the 44th Chief Justice of India from January 4, 2017 to August 27, 2017 and was Supreme Court judge from September 2011 to August 2017. He was part of several landmark rulings including those on the NJAC, the right to privacy, triple talaq wherein he had a dissenting opinion, and the Nabam Rebia case which was related to the restoring of the Congress government in Arunachal Pradesh. Senior advocate C.S. Vaidyanathan has been honoured with the Padma Shri. Both recipients were selected for the Padma Awards under the Public Affairs category. The Padma Awards, among the country's highest civilian honours, are presented in three categories, namely Padma Vibhushan, Padma Bhushan and Padma Shri. These awards recognize excellence across various fields including art, social work, public affairs, science and engineering, trade and industry, medicine, literature and education, sports and civil service. The Padma Vibhushan is awarded for exceptional and distinguished service, the Padma Bhushan for distinguished service of a higher order, and the Padma Shri for distinguished service in any field. The awards are announced annually on Republic Day. In the case of Ramesh Baghel vs. State of Chhattisgarh and others, the Supreme Court delivered a split verdict on a plea filed by a Christian man from Chhattisgarh seeking permission to bury his father, a pastor, either in the burial ground of their native village Chindwara or on the private agricultural land. Justice B.V. Nagarathna supported the appellant's request to bury his father on his private property, while Justice Satish Chandra Sharma ruled that the burial should take place only at the designated Christian burial ground in Karkapal village, located 20 to 25 kilometers from the appellant's native village. Given that the deceased's body has been in the mortuary since January 7, the bench decided against referring the matter to a larger bench. Instead, they issued a consensual directive that the burial be conducted at the designated Christian burial site. Justice Nagarathna, in her opinion, noted that since the Gram Panchayat had not designated a burial ground for the Christian community, the appellant's only viable option was to use his private land for the burial. She considered this plea reasonable. The state's contrary suggestion that the appellant could bury his father at the designated burial ground in Karkapal village, located 20-25 km away from his native village, was impractical. The High Court, she observed, should have addressed the appellant's predicament by directing the Gram Panchayat to either allow the burial at the Mahara community burial ground or permit it on the appellant's private land. The village panchayat, she remarked, had abdicated its duty to ensure the burial of the appellant's father within 24 hours and had instead taken sides. Justice Nagarathna emphasized that denying the appellant access to the burial ground violated Articles 14 and 15 of the Constitution, a matter that could have been resolved at the village level had unnecessarily been escalated. She criticized the state's stance, which implied discriminatory treatment towards certain communities, undermining the ideals of secularism and fraternity. She stressed that fostering fraternity and brotherhood among citizens is essential for building a cohesive nation. Justice Nagarathna referred to the Supreme Court's observation in the Ashwini Upadhyay case, emphasizing that Bharat is a secular nation dedicated to safeguarding the fundamental rights of all sections as envisioned in the Constitution. She also cited Justice Chinnappa Reddy's renowned statement from the Bijoy Emanuel case stating, "Our tradition embodies tolerance, our Constitution upholds tolerance and we must not diminish it." However, Justice Sharma ruled that according to the Chhattisgarh Panchayat rules, burials are permitted only in designated locations. Therefore, an individual cannot assert an unrestricted right to bury a body at a location of their choice. The bench delivered its judgment in a case where the order had been reserved on January 22. During the two hearings, the court expressed its anguish over the situation, noting the distressing nature of a case where a man had to approach the Supreme Court to bury his father. The court emphasized its intent to resolve the matter amicably to ensure a dignified burial for the body, which had been in the mortuary since January 7. In Harshit Harish Jain and another versus the State of Maharashtra, a bench comprising of Justices Vikram Nath, Sanjay Karol and Sandeep Mehta ruled that the right to claim a refund of stamp duty arises from the date of execution of the cancellation deed. Consequently, the court directed a refund of stamp duty to flat owners whose claims had been denied due to limitation issues. The bench was hearing a case under the Maharashtra Stamp Act concerning the refund of stamp duty. Dissatisfied with delays by the developer in completing the project, the appellants cancelled their booking and executed a cancellation deed on March 17, 2015, which was registered on April 28, 2015. The limitation period for filing stamp duty refund applications was reduced from 2 years to 6 months, effective from April 24, 2015. The respondent state rejected the refund claim, asserting that the appellant's application submitted in August 2016 exceeded the 6-month limitation period. They argued that the 6-month period applied since the cancellation deed was registered on April 28, 2015, rendering the earlier 2-year period inapplicable. On the other hand, the amended limitation period did not apply to their case, as their right to claim the refund originated on the date the cancellation deed was executed. They argued that the 2-year limitation period, which was in force at that time, governed their claim, making the August 2016 application valid. Dissatisfied with the High Court decision to deny relief, the appellants escalated the matter to Supreme Court. The court cited the case of MP Steel Corporation versus Commissioner of Central Excise, in which it was held that an amendment to a limitation provision does not apply to an already accrued cause of action, particularly when the amendment shortens the previously prescribed period. The court emphasized that the new limitation law should not invalidate an existing claim, especially when it would render the claim virtually impossible to pursue. As a result, the appeal was allowed. That was it for today, guys. For more such interesting updates, do keep following us. Till then, stay curious, stay legal.